program, and it is with great pride that I welcome you all to the 14th edition of our annual Monmouth College Moot Court competition. Before we begin, I wish to offer a few words of introduction and acknowledge those who have made this possible. Our Moot Court competition was founded over a decade ago by a very supportive alumni and friends of the college, including Dan Cotter, class of '88, Brad Narstad, class of '89, and Debbie Narstad. They were soon joined by one of our alumni, Kate Cross, class of '08. Together, these four individuals have supported our Moot Court program, both financially and through volunteering to serve on as judges for the preliminary round of our oral arguments competition, as well as judges of our legal briefs writing competition, the winner of which will also be announced this evening. Without them, this program would not be possible. We're also grateful for the judges who will be presiding over the case this evening. Serving as our Chief Justice is Circuit Judge Nigel Graham of the 9th Judicial Circuit of Illinois, based in Macomb. Accompanying him in the role of justices, we have our colleagues, Professor and Chair of Business and Economics, Mike Connell, and Professor and Chair of Theater, Vanessa Campagna. All of us are indebted to a number of individuals who help ensure that this program runs smoothly. While I'm not able to name everyone, Marnie Steach, Director of our Wackerly Center for Career Leadership and Fellowships, deserves special recognition for the many years of hard work in building this program and taking care of so many of the logistics. We really appreciate that. Professor Valerie Deisinger here as well has been assisting this year and is one of our pre-law advisors. I would also like to thank our communications and marketing office for providing the live stream and coverage of today's event, and Aramark for providing our refreshments. Finally, I'm grateful to the 16 students, 4 of whom are here today, and we have a couple in the audience as well, who have participated in this program and ensured that it is very competitive this year. And we are very happy to have them with us. I would now like to make a few procedural notes. During the competition tonight, we would like to ask that you hold your applause until the end of the competition. If you have not already done so, please silence any phones or electronic devices. All right. I will shortly introduce our competitors and then use the traditional cry of the US Supreme Court to begin the competition. But first, let me say a couple words about the case. The case before us today is Tilo et al. Versus the United States of America et al. The case involves the interpretation of the Citizenship Clause of the 14th Amendment as it applies to individuals born in the territory of American Samoa. This is based on a 2021 case, Fitzsimonu et al. Versus the United States et al., which went before the 10th Circuit Court of Appeals. The petition for certiorari was fully briefed with multiple amicus briefs in the United States Supreme Court, where the petition eventually was denied in October of 2022. I personally find this case interesting because it involves people and places which are part of the United States and are mooters, as moot court participants are frequently known. They are going to argue how much a territory like the American Samoa should be considered as part of the US. These are places that the average American likely knows nothing about. And additionally, while we are used to debates about citizenship in American politics, this addresses the issue from a very different perspective. The petitioners, representing the American Samoans, Tilo et al., will go first, and they'll have opportunity to reserve time for rebuttal at the end. Our petitioners today are Taylor Whitaker and Dean Duncan. The respondents are representing the United States of America and the American government of Samoa. They are Shannon Smith and Carly Strong. The Honorable Chief Justice and the Associate Justices of the Supreme Court of the United States, oyez, oyez, oyez. All persons having business before the Honorable, the Supreme Court of the United States, are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Thank you. You may be seated, please. All right. Good evening,
Council, would you please introduce yourselves?
I'm Dean Duncan, and I will be representing petitioners.
Thank you.
My name is Heather Whitaker, and I'm also representing the petitioners.
My name is Shannon Smith, and I'm representing the respondents.
My name is Carly Shaw. I am second counsel for the respondents.
All right, thank you. And Council, you may proceed when ready.
May it please the court, my name is Taylor Whitaker, and I represent Mr. Tilo and Mr. and Mrs. Gabber, petitioners in this appeal. At this time, I would like to reserve 2 minutes for my rebuttal. The American Samoa is one of several United States territories and is the only one whose inhabitants are not birthright American citizens. This is including Puerto Rico, Guam, and the U.S. Virgin Islands. Samoans are considered non-citizen nationals, but not citizens of the United States, and are able to work and travel freely within the United States with restriction. According to the Citizenship Clause of the 14th Amendment, all persons born or naturalized in the United States are citizens of the United States and of the state wherein they reside. In 1900, American tribal leaders ceded sovereignty to the American government. This did not define how they would be governed, nor did this address whether American Samoans were or would ever be American citizens. Since then, American Samoans have owed permanent allegiance to the United States. The United States has since provided protection from external interference while staying out of the internal affairs of the territory. There are 3 reasons to reverse the Court of Appeals decision. First is through the plain language of the constitutional text, second is through the history of the constitutional text, and third is through the common law principles. As it relates to the plain language of the constitutional text, American Samoa is a U.S. territory, and its people should be granted automatic birthright citizenship. The 14th Amendment was ratified in 1866 to 68, and maps, dictionaries, courts, and censuses uniformly agreed that the United States territories were land in the United States. From 1866 to 68, Congress and Americans understood U.S. citizenship extended to everyone born within the nation's territorial limits who did not owe allegiance to another sovereign entity, according to these judicial opinions, maps, censuses, etc. According to the 14th Amendment Citizenship Clause, it plainly states, all persons born or naturalized in the United States and subject to the jurisdiction thereof are United States citizens. American Samoa is a territory of the United States, and people born in American Samoa are born on American soil. Therefore, they should be granted automatic birthright citizenship to the United States. Through the jus soli doctrine, American Samoans owe permanent allegiance to the United States and are subject to the jurisdiction of the United States. In turn, they should be granted automatic birthright citizenship of the United States. As it relates to the 13th Amendment, it states, within the United States or any place subject to their jurisdiction, the or seems to point more broadly to territories like American Samoa. American Samoans owe permanent allegiance to the United States and are subject to the jurisdiction of the United States. In turn, they should be granted automatic birthright citizenship. As it relates to the Territories Clause, it states, the Congress shall have the power to dispose of and make all needful rules and regulations respecting the territory or other property belonging to the United States, and nothing in this Constitution shall be so construed as to prejudice any claims of the United States or of any particular state. This plainly states that territories or properties are belonging to the United States. American Samoans owe permanent allegiance to the United States. And due to them being a territory of the United States, are subject to the jurisdiction of the United States. In turn, they should be granted automatic birthright citizenship. As it relates,
Taking you back to the distinction between the 14th and 13th Amendments, are you advocating that those amendments be read together?
those amendments should be read separately, but have their purpose each individually. They can be brought together, but we're looking just at the plain language of how they're read.
Okay, so then the distinction between the two being that the 13th Amendment specifically refers to any place subject to their jurisdiction, whereas the 14th only refers to the United States. How do you account for that difference?
So the account of the difference for the 13th Amendment says or. So I'll say it again, within the United States or any place subject to their jurisdiction, whereas the 14th Amendment just says all persons born or naturalized in the United States and subject to the jurisdiction thereof. So the or seems to point more broadly towards territories like American Samoa.
Thank you.
As it relates to the history of the constitutional text, U.S. territories ceded by the United States government are considered United States soil. In 1868, Judge John's legal dictionary defined territory as a portion of a country subject to and belonging to the United States, which is not within the boundary of any state. An 1867 edition of Webster's dictionary defined territory as a tract of land belonging to a state, a portion of a country not yet admitted as a state into the Union, but organized with a governor. Contemporary dictionaries regarded territories as in the United States. An 1857 map of United States territories such as Washington, Oregon, Nebraska, Nevada, Utah, New Mexico, Arizona, Dakota, and a then Indian territory later known as Oklahoma are examples of this. Similarly, you are able to be citizens of the United States without being a citizen of a state. We can look at District of Columbia as an example of that. As it relates to the common law principles, common law viewed everyone born in the sovereign's dominion as subject to the sovereign. Dominion here is a broad concept that includes colonies and dependencies. When the sovereign changed with the American Revolution, the common law concept of citizenship remained, continuing the fundamental rule of citizenship by birth within the United States dominion. Wong Kim Ark was deemed a United States citizen by reasoning provided by the court that states, the 14th Amendment affirms the ancient and fundamental rule of citizenship by birth within the territory, and the allegiance under the protection of the country. The court observed that the citizenship clause in clear words and in manifest intent includes the children born within the territory of the United States, of whatever color or race domiciled within the United States. In Gonzalez versus Williams, the court further decided that the territory of Puerto Rico lies within the dominion of the United States. From this logic, American Samoans should be granted automatic birthright citizenship as well.
Counselor, one of the obligations of American citizenship is that males must register for the draft and be drafted if called. Would American Samoan, do you advocate that for American Samoans?
American Samoans, I'm actually not too sure, Your Honor, on the drafting part of American Samoa.
Well, I mean, obviously, if they were citizens, they would be subject to registering. You're acceptable, that's acceptable?
I do think it's acceptable. Obviously, if they had automatic birthright citizenship, they would be drafted into, the military if their services were to be needed. But I will also add that American Samoa has probably one of the highest enlistment ratings for the United States alone. So as it is, they're fighting for our country at a majoritively higher rate than any other American birthright citizen.
Thank you.
So to continue, American Samoans are considered non-citizen nationals, which means their currency is the US dollar. They have to pay federal income taxes to the US federal government, but they cannot vote, be elected, or be on a jury. They have the right to move to the mainland of the United States, but are limited in getting state or federal jobs, and in some instances, driver's license. The American Samoan Commission was created in 1930 to support and fight for the birthright United States citizenship. It had great amount of public support, and obviously it would not exist if people were not for it as an entity. The American Samoa can still be a self-governing entity while also being granted American citizenship. American Samoans do not have to abandon their culture, values, and lifestyles to be granted automatic citizenship as it is plainly stated in the Constitution. By reasoning of the plain language of the Constitution, the history of the constitutional text, and by the use of common law principle, we respectfully request that this court reverse the Court of Appeals decision. Thank you.
Council, I'm gonna have you stay up there for just a moment, please. Your use of maps and censuses and dictionaries from the time period, applicability is evident to me there. Can you take me back to common law? Because those cases don't ever seem to address, certainly not in a pointed way, a situation like that facing the territory of the American Samoa. So can you help me understand how that is applicable here?
Well, I'll take you back to the Wong Kim Ark case where, this individual was a citizen of California. Again, this is even way before California was a territory of the United States. And even if we move forward again with the American Revolution and, these states became, part of the Union. Like I said, as it relates to even the District of Columbia, where you can be, you don't have to be a state in order to be, considered part of the United States and to be granted automatic birthright citizenship. So even as it relates to, like I said, with Wong Kim Ark, and in the fundamental rule of citizenship as it was applied in that situation, American Samoans should be granted the same exact thing regardless if California is a state in the Union now or not. Like I said, California was a territory before, American Samoa was a territory, and these individuals should be granted automatic birthright citizenship.
Do you place any sort of importance on the distinction between incorporated and unincorporated territories?
So, yeah, so the use of unincorporated territory had no meaning when the Constitution was written, nor did it have any meaning when the 14th Amendment was ratified. And even when American Samoan territory was ceded to the American government, unincorporated did not have any meaning whatsoever, so it is not applicable with this appeal.
Okay, but can we agree that the maps you referenced appear to be of territories that then became states?
In that situation, I would consider it to be different because they were intended for statehood. American Samoa is not intended for statehood, nor are they wanting to be incorporated into the Union of the United States. They're simply looking to be granted automatic birthright citizenship.
Thank you.
Thank you.
I'd like to reserve 1 minute of time for rebuttal. May it please the court, my name is Dean Duncan. I am second counsel for the petitioners, Mr. Tooley and Mrs. Gabbard. The second issue of this case is whether the Supreme Court or Congress should decide the citizenship of the American Samoans. Ultimately, the Supreme Court should decide the citizenship status because it is an issue of the 14th Amendment. First, I would like to establish that American Samoa is a territory of the United States. Maps, dictionaries, censuses are included territories as part of the United States from back when the 14th Amendment was written. In fact, John Bouvaire's legal dictionary from 1868 described a territory as a portion of the country subject to and belonging to the United States which is not within the boundary of any of the states. This is important to consider because the 14th Amendment specifically states anything under the jurisdiction of the United States government. This applies to American Samoa as a territory. The fact that American Samoa was also peacefully seceded to the United States by the American Samoan chiefs is important to consider. They were under the assurance of equal treatment as U.S. citizens and respect for their customs and laws. Now, on to the 14th Amendment. The plain language of the 14th Amendment and the understanding of the amendment at the time are that birthright citizenship would be guaranteed to all peoples within the United States, and as previously stated, American Samoa is a territory in or part of the United States. The understanding of the constitutional amendment when they were written and passed is how we really should interpret them today. In Missouri v. Holland, it was is quoted in saying, "To learn the meaning of the text, we consider the lens of the 1866 Congress, which drafted the Citizenship Clause, and the state legislatures which ratified the clause from 1866 to 1868. The reason this is important is because at that time, the United States had just finished fighting the Civil War, and Congress, the people who wrote and ratified the amendments, did not want slavery to be perpetuated or any of these racist beliefs to be perpetuated. So they wrote the 14th Amendment intending it to apply to territories and apply very broadly as to prevent the continuation of racist and oppressive practices. And as for the distance, America, in Crandall v. The state of Nevada, U.S. citizens included inhabitants of the most remote states or territories. American Samoa may be on the other side of the planet, but is still a territory, and it's important to consider that. Now, as for Wong Kim Ark, most important to our argument is that the Supreme Court did make a decision. That is a thing I want to establish, that the Supreme Court making a decision means that they can make a decision on this in the future. This isn't new ground. This isn't a new idea for the Supreme Court to make a decision on citizenship, especially with regards to the 14th Amendment. And from the quote from Wong Kim Ark, the 14th Amendment affirms the ancient and fundamental rule of citizenship by birth within the territory. This is an example of jus soli, which is a part of common law. Jus soli is important because it continues the belief that Americans born wherever America is should be citizens. It also continues common law. Common law is important in this case because many American legal and political systems and practices are based on or use examples of common law. So it's not right to not include common law or to disagree with common law simply because times have changed. Now, the issue with leaving the decision to Congress is that the insular cases are inherently racist. They were written at a time when many Americans considered people who weren't white, who weren't from America, to be less than human. I believe, quoting from memory, that they stated that the people of these territories did not deserve or could not properly use the rights granted to them by American citizenship. And in allowing that belief or idea to continue, we perpetuate this belief that certain peoples are not able to use American citizenship to the fullest, which is ridiculous. We know that that's not true. There's also the fact that citizenship should not be decided by a rotating door of elected officials whose opinions may change from election to election. If citizenship were decided on policy alone, citizenship may change every single couple of years because of how politics change. We should not consider the political movements of our nation to ultimately decide citizenship. If I was decided to be a citizen or someone else was decided to be a citizen because of the sways of politicians, it could change from day to day, and we don't want that, especially with something as important as citizenship.
Can I ask you a question about insular? Council, do you see an avenue by which the insular framework could be turned on its head and used as a way to protect indigenous culture?
Yes, I do, but I think that, well, Congress could do that. I believe the Supreme Court could do it better. I believe the Supreme Court could ultimately defer those types of decisions to the American Samoans, whereas Congress would have a much harder and longer time getting through that process. I think the Supreme Court could quickly and efficiently make that decision.
Thank you.
For these reasons, the court should reverse the previous rulings and affirm that the Supreme Court should decide the citizenship of the American Samoans because it's ultimately an issue of the 14th Amendment. Thank you.
Counselor, so you argued that we should respect common law. Common law comes from England.
Mhm.
Does England have birthright citizenship?
At this point, I'm not aware, but I know that the way England historically handled many of their territories is not something we should emulate, but we should, however, respect the parts of this country, the way this country was built. I don't think we should entirely take from foreign countries, especially on issues like that, because the way England and or Great Britain, whichever one we want to talk about, the way they treated their colonies was abhorrent, and we don't want to treat our colonies the same way. So I don't think we should consider the beliefs or actions of England or a foreign nation in deciding what our citizenship is.
Thank you.
Council, I'll ask you to say, did I hear you correctly on, quote, some Americans are not able to use citizenship to the fullest extent, and that is not true?
I believe so that I said that.
Okay, then I'm gonna ask you to elaborate if you don't mind. What about incarcerated populations, especially those who are wrongly accused and perhaps even convicted, and are not as free as I am with an upcoming election, for instance?
Well, I think it's important to consider that those people went through a trial. We have not given the American Samoans a trial. Each person of American Samoa has not been given a trial to determine whether they could use their rights. I think that this is a situation for us to do that, to give the American Samoans their trial to decide if they should be a citizen or not. And I think that's why the Supreme Court is a better option, because the Supreme Court can consider the facts, consider all these things, can hear both sides' arguments, just like a criminal court.
Thank you.
That's all.
May it please the court, my name is Shannon Smith and I represent the respondents in this appeal. The issue being contemplated today is regarding the land of American Samoa, which includes 5 islands and 2 coral atolls in the Pacific Ocean south of Hawaii. For over a century, this land has been unincorporated territory, according to both the American government and the American Samoan government. American Samoans are not and have never been considered United States citizens, as they cannot vote, hold federal or state elective offices, or serve on federal or state juries. While petitioners, 3 Native American Samoans who now reside in a U.S. state, want this court to declare all American Samoans U.S. citizens, we argue that this should not occur, as this isn't representative of all American Samoans. The Court of Appeals ruled that the petitioners in this case should not be granted United States citizenship, and we are asking this court to uphold its decision for a couple of reasons. For starters, American Samoans do not have birthright citizenship based on the plain text of the 14th Amendment Citizenship Clause. Furthermore, the interpretation of the language within a single clause of an amendment should not contradict the historical practices of the United States government. Today we are arguing that the plain text and the geographic scope of the 14th Amendment Citizenship Clause is too ambiguous and broad, not guaranteeing birthright citizenship for American Samoans. The plaintiffs argue that the plain text of the Citizenship Clause should be interpreted to include American Samoans as U.S. citizens. However, this is not the case. The Citizenship Clause states that all persons born or naturalized in the United States are considered U.S. citizens. We argue that this language is too ambiguous when taken at face value to consider individuals of unincorporated territories U.S. citizens, especially looking at the context of other U.S. amendments and uses of "in United States" within them. Previous courts and judicial decisions have concluded that the Citizenship Clause's geographic scope is too ambiguous to be considered alone. For example, in Chihuahua v. United States, the courts determined that the American Samoans did not have citizenship because the Citizenship Clause may not be readily available or discern plain text or other indica of the framers' intent. Furthermore, the Insular Cases framework also upholds this understanding. In Downs v. Bidwell, Justice White argued that the determination of what particular provision of the Constitution is applicable in an unincorporated territory involves an inquiry into the situation of the territory and its relation to the United States. In this case, the circumstances within the territory of American Samoa do not warrant the application of constitutional provisions being applied to it. In the case examining BD of Engineers v. Flores, the courts consider whether a constitutional provision applies to unincorporated territories by its own terms. In the case of the Citizenship Clause, the language does not apply to unincorporated territories.
Counsel, can we agree though that the concept of an unincorporated territory was not in existence at the time of the ratification of the 14th Amendment?
Yes, well, at the time, the framers of the 14th Amendment didn't recognize the further scope of the United States in the future. That is exactly why we're arguing that we need to take a more pragmatic view of this, because currently we do differentiate between unincorporated and incorporated territories, and previously the territories that they recognized as being territories eventually were intended on becoming states and did eventually become states. So they were intended originally for statehood.
Thank you.
Furthermore, in the case of the Citizenship Clause, the language does not apply to unincorporated territories, as it is too broad, and because it is not explicitly stated, it should not apply to unincorporated territories. Looking at other constitutional amendments, we can see that the other uses of "in the United States" suggest that there is a distinction to be made between being within the United States or elsewhere, and we argue that this differentiation refers to the territories. For example, in the 13th Amendment, it states that slavery should not exist within the United States or any place subject to their jurisdiction, suggesting that there is a difference between being within the United States and being outside of it, as well as subject to the jurisdiction of it, such as U.S. territories. Another example of a constitutional provision addressing the distinction between being in the United States and outside of it is the Territories Clause, which states...
So, as I understand, any individual American Samoan can ask for citizenship, but I really don't understand, why does the government care? If it's okay for some, why isn't it okay for all? Why do we want to keep these people out?
Well, in this case, 3 American Samoans who currently reside in the United States are asking for United States citizenship. They already have it, but this doesn't account for all American Samoans. A large portion of American Samoans do not want citizenship, as they want to preserve their own culture, and they want to preserve their history of being separate from the United States in that way and just being a territory.
So they don't want this unwanted gift?
I'm sorry?
They don't want this unwanted gift?
Yes.
On that note, you mentioned that the American Samoa do not want birthright citizenship writ large. Is there evidence in the file of that? I understand that the government is representing on this case, they are involved, But where's the evidence that that is not what the average American Samoa person wants?
I mean, the evidence is that only 3 American Samoans are appealing to this court, not a larger amount of American Samoans. And we can see that there have not been many other attempts in the past to make this occur. So, just like I said, this doesn't account for all American Samoans.
So we're assuming that want has to be read within the context of taking a step toward that want.
Correct. In the Territories Clause, it states that Congress shall have power to dispose of and make all needful rules and regulations respecting the territory or other property belonging to the United States, suggesting that the territories are property of the United States as opposed to a part of it. Under both of these lenses, we can see that the plain language of the Citizenship Clause is too ambiguous, and its language should not be taken at face value without the other context of and practices considered due to its ambiguity. While petitioners cite that Wong Kim Ark should be applied to this case, arguing that it should grant American Samoans U.S. citizenship, we argue that Wong Kim Ark should not be applied to this case. Wong was born to two Chinese citizens in the state of California, and the question of his citizenship was brought to court when he was denied re-entry into the United States. While petitioners argue that the common law consideration brought up in Wong should be applied to this case as well, our interpretation of English common law and how it was used in Wong does not support the argument that American Samoans should be granted citizenship. First of all, the courts in Wong Kim Ark merely suggested the citizenship clause should be interpreted in the light of the common law, or in the context of, as opposed to a final statement of authority. Moreover, because Wong was born within the bounds of the United States, the state of California, the common law application was mainly brought up to question Wong's allegiance to the United States as opposed to his birthright citizenship itself, as he was born in the United States.
Do you believe that Wong Kim Ark extended citizenship to birth within the sovereign's dominion? I believe is the language of that case.
Yes, that was the language of the case, but Wong was born within the dominion of the United States, whereas the territories we're arguing are not within the dominion of the United States. The common law application was mainly brought up to question Wong's allegiance to the United States as opposed to his birthright citizenship. Wong should simply not apply to this case, as California was not an unincorporated territory at the time, and American Samoa is. Both allegiance and being within the dominion of the United States are questioned in this case. We hold that American Samoa is not within the dominion of the United States. Furthermore, while petitioners argue that there are inherent racist underlying principles in the insular cases, we argue that they should be applied based on their framework and upholding cultural autonomy. The insular cases have been repeatedly upheld in other courts and have also been upheld to argue that Congress should decide in matters of citizenship, showcasing the historical significance of them. The current American Samoan law states that each individual Samoan can seek American citizenship if they choose to do so. This court should not set the precedent that will inevitably force American citizenship upon American Samoans. The insular framework allows us to respect the wishes of the American Samoan people and allow them to uphold their cultural preservation that would inevitably be lost if citizenship was forced upon them. Finally, the legislative history that the plaintiffs cite as evidence that the Citizenship Clause should apply to the United States territories is not persuasive. While they argue that the framers of the 14th Amendment understood the Citizenship Clause as applying to the territories, we hold that we should take into consideration the historical practices of the American government, as well as other constitutional amendments, to understand the application of the Constitution to unincorporated territories. We conclude that the Citizenship Clause's language and geographic scope is too ambiguous to grant American Samoan citizenship in this case. When taking into the context the historical practices of the United States, never deciding on matters of citizenship in accordance with the constitutional provision, we can see that American Samoans are not considered birthright citizens of the United States. We respectfully request that this court affirms the Court of Appeals decision. Thank you.
Counselor, when I read, and I wish I could find this, remember the fact, a large number of American Samoans moved to the mainland. Wasn't there many more in the U.S. than on there? Isn't that in the notes?
I'm sorry, can you rephrase the question?
Don't a large number of people move to the mainland, a large percent of American Samoan?
Yes.
Doesn't that indicate that they want to be American citizens?
Well, those individuals make the decision to do that for themselves, but the government and the courts should not decide that for all American Samoans, as the other ones that are still on the islands are there for a reason.
Thank you.
Thank you.
May it please the court. My name is Carly Strom, second counsel for the respondents, United States of America and the government of American Samoa. This case is also considering whether the Supreme Court or Congress should decide the citizenship status of American Samoans. Facts of this case are that the plaintiffs were born in American Samoa. American Samoa is one of the several unincorporated territories of the United States, and that federal statute designates American Samoans as nationals but not as citizens of the United States. This court should affirm the appellate court and hold that Congress should be the body to decide the citizenship status of American Samoans for two reasons. One is that Congress has historically decided these status of American Samoan citizenship of the unincorporated territories overall as well, and that the framework of the insular cases must guide the court's analysis of regarding this citizenship status to unincorporated territories.
I hesitate to interrupt you so soon. You said historically. Do you give me an example? Is that Puerto Rico? Is that Congress made those decisions?
I can give you that, Your Honor. Congress has decided the citizenship status of territories like Guam, that was August 1st of 1950, Puerto Rico, March in 1917, and the U.S. Virgin Islands in 1917 as well, and then the Northern Mariana Islands in 1986.
And those were all congressional decisions, not Supreme Court decisions?
Yes, Your Honor.
Thank you.
As I previously stated, Congress has historically decided the status of citizenship of the unincorporated territories like American Samoa. This practice has been done for over hundreds of years, or over 100 years. Around this time, there was a practical need to determine how citizenship status would be determined after we acquired lots of territories during the Spanish-American War in 1898. And that was granted to Congress and has continued to be determined for overseas territories since then. Citizenship for those in the U.S. territories was prescribed by ad hoc legal procedures as well. So treaties, acts of Congress, administrative ruling, and rather than an individual automatically guaranteed constitutional right as well when we're talking about the citizenship clause. So we can also look to the territories clause for this, because the territories clause grants Congress the power to regulate, influence local governance, and have the power to determine what constitutional rights are extended to those unincorporated territories. So it states that Congress shall have the power to dispose and to make all needful rules and regulations respecting the territory or property belonging to the United States. Again, citizenship falls under more of a legislative and policy making when we're talking about these unincorporated territories, because these are still territories that are not intended for statehood. We can also look to American Insurance Company, the 356 bales of cotton in 1828. The Supreme Court addressed the status of Florida's inhibitants upon Spain's secession. So the Supreme Court also at that time held that Congress should have the constitutional authority under the Territories Clause to establish courts in U.S. territories with judicial powers. As was previously stated by my co-counsel, Downs v. Bidwell established that Congress has the broad power to govern newly acquired territories and not apply all of the provisions of the Constitution to those unincorporated territories like American Samoa. This was chosen by the Supreme Court. The Supreme Court has continued to give this power to Congress. So again, I want to reiterate that those incorporated territories are those that are intended for statehood, whereas American Samoa, being an unincorporated territory, is not necessarily determined for statehood, and this is why the constitutional provision should not automatically be applied to them.
Counsel, can you indulge me on something? So the point of a constitutional amendment is to put an issue beyond the scope of congressional power, correct? The 14th Amendment was passed to ensure that birthright citizenship was beyond constitutional power. So if the 14th Amendment does apply to Samoa, would you agree that that would make this issue beyond legislative decision-making?
Your Honor, this is where I would also continue to argue, based off of what my co-counsels also said. Birthright citizenship status under the Citizenship Clause does not extend to American Samoans because of the fact that they are an unincorporated territory. So that's why this conversation of, you know, if it's been misinterpreted for this many years, should it be given to the Supreme Court now? And my argument is it hasn't been misinterpreted, it's been interpreted the way it should have been this whole time. So that's why we should leave it in the hands of Congress, since they have been interpreting it correctly for hundreds of years now.
Thank you.
So I also want to relate back to Downs v. Bidwell and also provide this idea of the cultural autonomy, because it also provides significant latitude for the preservation of cultural practices like seen in American Samoa. They could be completely disregarded if we were to just extend this birthright citizenship with no basis for what they actually want. Again, if this choice is left in the hands of the Supreme Court, it could unnecessarily force citizenship status onto American Samoans. And as previously stated, American Samoans can seek citizenship status on their own. There's nothing that prohibits them from doing that. And we have seen that some do choose to do that, but the ones that would like to remain on the island and not have that birthright citizenship status extended upon them should not be forced to do that.
Council, you mentioned the worry about disregarding the cultural practices of the American Samoa. And yet, your argument also points to the insular cases, which are rife with racist and imperialist connotation. There's a tension there for me. So let's say that we took the insular cases out entirely. Do you think your first argument about court precedent is strong enough on its own?
Your Honor, I would still argue yes, it would be strong enough on its own, but I still think we do have to consider those insular cases because they can be repurposed for that cultural. You could regard that they have some racist underpinnings, but again, this idea that we can spin that on its head and again, preserve this cultural autonomy that American Samoans want. And again, as I've said before, they do not want to remain in the island of American Samoa and they want to become US citizens. They have the right to saying that they shouldn't have a right to do that. We are saying that them, along with their government, do not want those extensions put upon them because again, it can completely threaten and ruin their cultural practice that they have. One of those being that if they are not a certain percentage of American Samoan, they aren't able to own land in American Samoa, which is a huge problem. So I still think that it's a strong case without it, but I do think that it's important to note that the insular cases can be repurposed for cultural preservation.
Thank you.
As I stated earlier, Congress has decided citizenship status for many of the territories that we have gotten over the years, that again being Guam, Puerto Rico, US Virgin Islands, and islands. I also want to note that the American Samoan Commission recommended during the time in 1930 when they came together to discuss this issue of citizenship that even at that time, Congress should be the body to determine citizenship in the territory if they were encompassed under the plain language of the Citizenship Clause, which again, we have learned they are not encompassed, therefore they are not citizens of the United States. And then in Igratua de la Rosa, the United States in 2005, they further emphasized that the Supreme Court does not have the authority to extend rights like voting that would involve amending the Constitution, and that it should remain given to Congress. In Walls v. Tax Commission's City of New York, 1970, it does state, an unbroken practice conducted by affirmative state action is not something to be lightly cast aside. We should not just cast aside this practice that we've used for over 100 years now based off of one case that we've had where the Supreme Court decided on a citizenship status. So the petitioners are arguing that the extension of citizenship should be determined by the Supreme Court, but again, the Congress has the full capability and capacity to actually look at the scope of that, so it should continue to be their responsibility to cover that for the unincorporated territories. And again, the precedent set in the insular cases and Downs can be repurposed for that cultural preservation of their culture and their traditions and their practices. And then into it would be United States in 2015, one of the most recent cases regarding this exact same issue of birthright citizenship under the Citizenship Clause. This case also relied on the insular cases and held that Congress should be the ones to determine whether or not American Samoans are citizens under the Citizenship Clause. I want to get to my second point now of Wong-Kim Ark not being applicable in this case, and it should not guide the court's analysis in this. Again, Wong-Kim Ark is about whether a man that was born in California to two non-citizens from China, whether or not he is a birthright citizen. Again, not only does this case being in 1998, which is predating this idea of American Samoa, and then also the unincorporated territory. But even then, it doesn't apply because this person was born in California, which was at the time, something that was going to be destined for statehood. And if you want to bring in the unincorporated versus incorporated, it's important to have those distinctions still because we needed to determine how we were going to govern those that were going to be states, whereas how are we going to govern those that are not going to be states. And again, the idea of common law, Wong-Kim Ark does not require the English common law be the ultimate authoritative decision on citizenship overall.
You discussed some factual distinctions in Wong-Kim Ark, but aren't there also some factual distinctions with respect to the insular cases, primarily Downs, as that had nothing to do with citizenship, but that was a case about duties and excises and such?
Can you rephrase the question, Your Honor?
Part of your argument is that Wong-Kim doesn't apply because it's factually distinct insofar as it involves a person born in California. However, by that same token, the insular case, if we're looking in terms of the facts of that case, didn't have anything to do with citizenship. It had to do with excises and taxes.
Mm-hmm. Yes, Your Honor. I would continue to argue that, again, this distinction of incorporated versus unincorporated still does apply to this idea of how we are going to govern in these areas, which still does apply to those citizenship statuses. I also see that I have made time, so can I have a moment to conclude?
You may.
Thus, the long practice and history of Congress deciding the citizenship status of those in unincorporated territories should continue to be decided by Congress. It can continue to uphold and support these cultural practices and traditions that American Samoans have. So for these reasons, that this court should affirm the appellate court and hold that American Samoan citizenship status should be determined by Congress. Thank you.
Thank you.
So as it relates to the opposing counsel, they did bring up the distinction between unincorporated versus incorporated territory, and I would like to reiterate that unincorporated territory had no meaning when the Constitution was written, nor did it have any meaning when the 14th Amendment was ratified, nor did it have any meaning when American sovereignty was, American Samoa was ceded to the United States government. American Samoan land was acquired during the period in which unincorporated territory had no meaning, so no one considered American Samoa either unincorporated or incorporated. According to the Commonwealth of North Mariana Islands versus Atalig, an unincorporated territory is defined as a territory not intended for statehood. American Samoa is not looking to be granted statehood. They're looking for automatic citizenship since they are born on American soil. So the wording is irrelevant. Similarly to the District of Columbia, you are able to be a citizen of the United States without being a citizen of a state. Territory as defined by the U.S. Department of Interior in 1849 as an unincorporated U.S. insular area of which American Samoa is included. Here, insular area is defined as a jurisdiction that is not part of a state nor a federal district, but may refer to the jurisdiction which is under the United States, but also to one that is not. So, again, to reiterate, the American Samoa can still be a self-governing entity while also being granted American citizenship. American Samoans do not have to abandon their cultures or their values or their lifestyles to also be granted citizenship as it is plainly stated in the Constitution. By reasoning of the plain language, the history of the constitutional text, and the use of common law principle, we respectfully request that the court reverse the Court of Appeals decision. Thank you.
To take a very wide view of this issue, if it's not crystal clear that the 14th Amendment was meant to include unincorporated territories, why not just leave this issue to Congress?
It wasn't with lack of trying for the American Samoan people. They did try to go through Congress, but it did not work there. And due to the fact that American Samoa is a U.S. territory and therefore are on U.S. soil, it's not right that Congress decided to not grant them automatic birthright citizenship, so they had to take a different avenue, which is why it went to the courts.
Thank you.
Thank you.
I'd like to begin with, the Supreme Court has routinely warned against expanding the insular cases and their powers. The opposition continually argues that the insular cases are important because it gives Congress ultimate authority over this. However, the Supreme Court keeps saying that we can't keep doing this, we can't keep allowing these decisions to decide what we should do in the future. Downs v. Bidwell is racist. We shouldn't keep expanding a racist belief and allowing power to be used off of that. That's not good precedent. It doesn't set a good example for the rest of the world or for Americans. Wonka Mark is applicable because ultimately the context for our argument doesn't matter. It's the fact that the Supreme Court made a decision when in reference to someone's citizenship. I think that's ultimately what we should consider, is that the Supreme Court thought it was important enough to decide on someone's citizenship, which is what they should do for the American Samoans. And as for the idea of destined for statehood, I would like to bring up Alaska, which was made a territory in 1867 during the process of creating the 14th Amendment. And I would like to once again repeat that these reasons, the court should reverse the previous rulings and affirm that the Supreme Court should decide the citizenship of the American Samoans because it's ultimately an issue of the 14th Amendment.
One moment, counsel. To ask you also a broad question, do you consider Samoa to be identical to, say, Illinois in a legal and political sense?
What do you, may you expand on that or elaborate more?
That's a broad question. I just want to know, we're advocating for birthright citizenship. So in making that argument, are you advocating that it's identical to one of the, say, contiguous 48 states like Illinois in a legal and political sense?
No, I'm not. However, my argument is just that the Supreme Court should decide. I believe it should be up to the Supreme Court to make this decision because you have examples like Hawaii and Alaska that are not part of the contiguous 48 but are states. And even though America Samoa is not destined for statehood, they don't want to become a state, Alaska and Hawaii were territories before they became states. If anyone in 1867, when Alaska was made a territory, thought that Alaska was going to eventually become a state, people would think they were insane because Alaska is so far away. However, Alaska did become a state. And it's important to consider the ramifications of a decision like this, and we should ultimately leave it to the Supreme Court because we respect the Supreme Court.
Thank you.
All rise. At this time, the judges will retreat into their chambers for deliberation. As they do, please enjoy some of the refreshments that we have available, and we will be out shortly. Good job. So enjoy refreshments, they'll deliberate. See how long? And come back with the results for this and for the review competition.
So frank.
It's been a long time since I actually like got all
Yeah, that was a little bit, it's always a little bit different.
I was like mid-levels and Doug like, well, even when he asked that last question, so I'll stop. I was like, I don't think I could just be like, I can't answer the question. My time is like,
Yeah, well, and that's, I know,
it's hard.
yeah, and I know in the, like, everything, all has there been a question answered and close to and as you're answering, then stuff comes up, and that's, I see sometimes expired, and I wrap up.
Yeah.
But they were asking the questions completely after, which was. Yeah, so I'm like, I don't know what to do here.
That's exactly. This is something that Yeah, right, exactly.
Your dogs are out.
Because the US does have laws or has requirements on how we even before then.
We could also grab some pictures once they.
Yep, well, I told her that as soon as we're, oh yeah, we can grab pictures of.
Just the students by themselves, yeah.
Yeah. Yeah.
At the same time, they're just advocating for the territory of the United States. The United States in some way or another does have jurisdiction over them. I think that one should be clear. They have jurisdiction over them. So they, and the fact that they allow the Samoans to go from the island to well, they allow it. Sure, yeah. They allow it. So, in theory, if Samoans give them a child to the United States, that child is but there are cases that can be made about the parents, though, yes, because they weren't born on the continental states. I don't know about no, only United States, but back then, before that, they would only reference the United States as really? I actually never got a chance to see that. I used to work, okay, so as you know, Chicago doesn't have an art museum. So I actually been to, I've been to a few museums.
Yeah, and
I've also been to Sheraton. Yeah.
so I've got, so they're just gonna start falling out in droves, and I'm gonna have this a bunch of times for you. So this is the first one. So then you're gonna root down most of the and then process.
Yeah, I should have thought about that.
So that's what I love science.
Because I don't know.
Yeah.
Like stand in the middle of it.
So I'm now in
Should we make it real fun like we did last year? How was that? Oh, yeah. I don't know. Actually, yeah.
Oh.
And I'm like,
Like they have a full on.
I remember looking at going, oh my god, this is like,
The full on picture.
well, it was all
That's
about
fun. Like that is actually kind of cool. We can take a serious one.
I'm also at already having.
Can you imagine? Like, I was a little uncomfortable.
Yeah.
But I was
There are-
holding on. And I was.
Yeah, because you know,
But that was the big one. I remember like,
scientists go to it. For me, personally, the scientists,
I think
they go into limits and they try to explain
That is the only
whether it was chemistry, biology. Like, think of that as just like crispy. Like if I went to the one version I'll ask you was called it's crispy. It's pretty crispy. And then everything will be. It's just that good. I actually did a journal.
Because you kept going. I was like, I know she's. What is this? Yeah, she was like this, and she was like, wait.
Hold on, it was
Look! Look! It's gone! I don't know what happened to it! It's gone! I woke up when it's gone!
Yeah.
Now I have practice in this, so like, I do want to. Exactly. No, but I want to. I would like to do civil and criminal. It would be fun. It would be a lot of fun. Yes.
Yeah, I did.
Can't get there. That's just, well, I just mean like putting
Yeah, exactly. It's a Saudi Arabian drug. He got it in Dubai, but he got it when he was in Dubai. This is how Supreme Court hearings
Actually, it's 10.
I've heard court cases I've never watched this court case. Actually, aside from
Right,
that,
yeah, right.
You read off the same section as me. I was like, I've seen the shows. There was a mock.
I was shocked.
Old jury
Saying why we should.
as a citizen,
So when you said that, I was like,
I know how far. I know how far this could go.
Yeah, you're right, yes, exactly.
like the Asian, instead of like This is what makes us unique. Last year's we didn't all have the same cases, and the whole also for like your yeah, your guys' pressure are Supreme Court. It touches on this
that one shit, that chip shop we hit today, and then there's another one that
I'm saying whether you say that American Samoa is the same, like, should have been like the same thing, because of Uniform 13.
You're internally hurting people.
American Samoa not, and I was like, it was like you were like,
Internally, you will harm everyone else. Accept that.
I like
Who's going to get harmed in the long
I like that. I was like, I like nothing else. If they were about to I thought that like it was like I'm just regarding that because I have no evidence that
jury judge.
Most of the time, they don't want
so we're using all of them to that.
I don't know why is this.
They wouldn't get it.
It's supposed to be the.
Wait, I said that?
Yeah, you like.
Probably not on purpose. I think I just. Well, I do that because like that's why I don't have that podium. Because the other one I could move. This is why I couldn't wear heels in speech because I would move my legs too much and I would push all day. And my speech coach would be like, "Go off your knees." But I'm used to it. I'm not used to move. And I'm like, I can't stand there like this. Or I feel like I'm
It was good talking.
well, what I have going, I was like, I didn't get it.
I figured, I was like, something.
That's the thing, I actually, I didn't pay for it, but I went to somebody that had paid for it.
I got asked a question. They asked you, I still can't remember what they asked you. They didn't ask.
It wasn't worth the.
And you didn't.
I won in my 1 minute rebuttal.
I hate
I like that.
Sometimes I can.
Bo, how you doing?
I'm very.
And you're like,
No,
well,
my
actually,
rebuttals are stupid because they don't know how to answer.
actually, pledge allegiance to the flag has nothing to do with it.
Yeah, I remember when you brought that up and then they said that and I remember I said there was they talked on it, don't bring that up, that gets real murky. So if you just don't want to talk about it, I would just.
I thought it was gonna be downstairs, I thought we'd be in that
You
minute.
should have brought it up when I was talking.
The last year was.
Yeah, so did I, yeah. So did I.
I got you.
I at least had all of that information to fill out my entire. I need to say it to me, I had to jump. I was saying, I skipped a little part of the long mark, so.
Oh, yeah, of course.
Oh, yeah. I didn't talk about how it was never mentioned in Downs, even though that was decided 3 years later by the same justice.
Also didn't say that.
I wanted to
because
say
I
that,
skipped over that.
but I ran out of time,
I
and it's like.
skipped over it. And I had it as like rebuttal points, like when one of them said about like Washington.
So tomorrow, guess what?
Mm.
I'm going in like that for
And tomorrow's not Halloween though. Oh, gotcha.
I'm doing that.
You got the bow tie and everything.
Oh wait, no, that's what I
Are
was
you gonna
gonna
do
cover
the,
you. I was like,
oh yeah,
just
because,
because
are you doing this, like the Cincinnati Reds bow tie? Yeah. Which one are you picking?
decided on that. And they ended up pushing for
Yeah.
They're getting ready, everybody?
It'll be nice.
And then we stand up.
Oh, nice. Oye, 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 rise. The honorable justices are here.
And thank you, you can be seated. All right. Suppose we will call the session back to order. My colleagues and I, after a robust discussion, we'll give feedback in a moment, but we'll cut to the chase. Extraordinarily close decision, but Ms. Strom, you've been selected as the winner. Congratulations.
Thank you.
In terms of general feedback, and I think we're all going to give our own feedback, I think I speak for all of us when I say we were incredibly impressed with the grasp that all of you had on this problem. It's an incredibly difficult, dense constitutional issue that I think outside of a few common law professors and some maybe former solicitor generals, I don't know of anybody who's ever touched anything like this. So in that respect, we were on a level playing field. I learned a lot while reading this, and you knew it far better than I did or probably ever will. So congratulations on that. And any specific feedback from
I'll
panel?
start. This is completely out of character for me. I'm gonna say all positive things. I thought all of you had a good deportment. You all spoke well and strong. You handled questions. You didn't get flustered. There were no ums, I thought you did your presentations were uniformly good, and I thought your research and arguments were uniformly good. So, well done.
I'm gonna give each of you one commendation and give you one thing to think about as you move forward, because I think you're all really accomplished at this, and I hope you have an opportunity to do moot court again, or to move forward in your careers if law is your passion and your goal. Taylor, I'll start with you. I thought you had clear organization and commitment to your agenda. You managed your time really effectively. Moving forward, I'd encourage you to remain actively engaged while others are presenting, particularly your respondents. Dean, I thought you had excellent professionalism. Obviously, I'm a theater professor, so this is coming from my background, but I really appreciate it. I think it makes you really effective. You took on the role and you maintained it. Even when you were in the wings, you were consistently engaged in the matter, and I really appreciated that. I would say, moving forward, be careful about really big, bold statements. that might take someone out of what you're actually trying to accomplish. That did happen with me. Shannon, good parallel construction of your introduction and your conclusion. Nobody could listen to you and get confused about what it is that you want to achieve. So your bookends was a really nice strategy. I also, moving forward, I would say just elevate your professional demeanor ever so slightly. You have really good posture. Do some more grounding techniques with connecting your feet to the earth and maybe using the podium just to stabilize yourself just a little bit more. Help you control those nerves a little bit. And Carly, I thought you had a great balance between the personal and the professional in your approach. I think if you were in a courtroom, that would really help with your judge and your co-lawyers, but also being able to reach the people on a jury if you were to move in that direction. I also, moving forward, I encourage you to think about what exemplars can I draw upon that are going to be most effective, right? So I'm tracking you when you suggest that racist documents can be retooled. But kind of in the same way that I'm telling Dean, anytime you say something so big and so bold like that, you might have somebody that's like, wait, should we really be repurposing racist documents though? And all of a sudden they're gonna stop listening to you for a moment. So just check those things. Am I really using the evidence that's going to keep people in my story as opposed to pull them out? Thanks. Good job, all of you.
Yeah, and as a kind of final, more specific discussion, so Taylor, as previously mentioned, your ability to stay on your argument and stay on your task was very good. You were pretty much unflappable in that regard. Dean, your responses to questions were very good, and that is, as I'm sure you can all sympathize with, probably one of the more difficult parts of this. To get up and deliver your brief is one thing, but to have to go on the fly, answer questions and then get back to where you were, and you all executed that just about flawlessly. Nobody really seemed to get tripped up or lose your place, but Dean in particular, I thought that you were quick on your feet, good with the responses. And Shannon, kind of similar feedback for you as well. Your structure was good, your responses to questions were good, and Carly, you have a good tone. It's easy. It's kind of the kind of tone that kind of gets people's attention, which is important, and good, strong advocacy. Any court reporter who's ever taken a transcript of mine is going to laugh hysterically when I say this. Everyone does need to slow down, but that I'm the last person in the world who is justified to make that statement, but it's for the good of the order. I would recommend that. And I would modify the statement of my colleague. I would ask you to ignore any other passions or interests you may have and go to law school and to this area to practice law, please, because you're all excellent. So thank you.
Thank you. And I have the great pleasure of also announcing the winners of the legal brief competition. In third place, we have Braden Arrhenius. In second place, Cameron Shook. And in first place, Peyton Crims.
Excellent. I would like to have us all offer thanks and gratitude to the judges. Really, this was a wonderful event tonight, but we couldn't have done it without you. So thank you so much. You did a great job, everyone. So even though he's the judge, I will say we are adjourned. But I would like to invite the judges up here for a few photos, if that's all right. And so we'll take a few photos. Otherwise, if people want to just hang out, we have lots of food. Take it with you if you want cookies and cheese. And yeah, thanks everyone for coming.
Thank you. You guys were great.
Thank you.
Well done.
A little more professional with this.
I was gonna say,
Nicely done. Nicely done.
So,
All seven
how do you want us to do the photos? Where do you want us to be? You want us to kind of like line up maybe in front here, maybe?
Group all together and
Yeah, all right.
make sure that.
Here, let's pull this
We wanna
table
do
out.
like
Okay.
versus
Did you
competitor
want to
judge,
stop
competitor
the-
judge.
Do you wanna come here?
Competitor judge, competitor
And then
judge.
Tom will go in between, and I'll come between here.